Prince Harry has indeed arrived at the High Court in London and his case against the publisher of the Daily Mail begins. The Duke of Sussex is one of a number of public figures who are suing Associated Newspapers Limited for breach of privacy.
Prince Harry's war with the British establishment has moved from palace corridors to courtroom battles, and the toll is becoming impossible to ignore. Over the past 5 years, the Duke of Sussex has launched an unprecedented legal assault against tabloid publishers, the British government, and anyone he believes has wronged him or invaded his privacy. But as 2026 unfolds, Harry's crusade is showing cracks that even his most loyal supporters can't deny. Judges have issued stern warnings about his legal team's conduct, and his security appeal has been decisively rejected. So what's really happening behind those courtroom doors? How much has this crusade actually cost him? Join us as we dive deep into the legal battles that have Harry in a state of shock. The phone hacking victory that started everything. To understand how Harry ended up fighting multiple simultaneous legal battles in 2025 and 2026, we have to go back to where it all began. His landmark victory against Mirror Group newspapers in December 2023. This wasn't just a win, but also a validation of everything Harry had been claiming for years about tabloid misconduct and the invasion of his privacy. Justice Foncourt's ruling delivered what Harry had desperately sought: official confirmation that he had been the victim of illegal information gathering. The judge found that 15 of the 33 articles Harry complained about involved phone hacking or other unlawful information gathering. MGN was ordered to pay Harry €140,600 in damages, a substantial sum that represented only part of his claims but carried enormous symbolic weight. But the real victory was the public vindication. For years, Harry had insisted that journalists had systematically invaded his privacy, hacked his phone, and used illegal methods to generate stories about his personal life. The royal family had quietly settled similar claims years earlier, taking payouts and moving on. Harry refused. He wanted accountability delivered in open court. When he testified in June 2023, Harry became the first senior royal to give evidence in court in over 130 years. The historical significance wasn't lost on anyone. For 3 days, the Duke of Sussex sat in the witness box, detailing years of paranoia and the psychological toll of never knowing if his private conversations were being intercepted. His testimony was intensely personal. He described how the constant invasion affected his relationships, made him distrustful of friends, and contributed to the breakdown of past romances. He spoke about feeling surveilled, about the coincidence of private conversations appearing in print days later, and about the emotional damage of seeing intimate details of his life splashed across front pages. The judge's ruling vindicated many of these claims. Justice Foncourt found that phone hacking at MGN was widespread and habitual during the relevant period. Journalists and private investigators had systematically targeted Harry, along with hundreds of other individuals, to generate stories and sell newspapers. MGN issued a public apology, something Harry had sought for years. The company acknowledged unlawful information gathering and expressed sincere apologies to the Duke. In February 2024, they agreed to pay substantial additional damages, bringing Harry's total compensation to over €440,000, plus the majority of his legal costs. The victory emboldened Harry. If he could take on Mirror Group and win, why not target every other publisher he believed had wronged him? Why not fight for security protection he thought he deserved? Why not use the courts to force accountability from institutions that had operated with impunity for decades? This mindset, understandable given his win, shaped everything that followed. He ramped up other cases and doubled down on his courtroom crusade. What he didn't fully appreciate was that winning one case doesn't guarantee winning them all. And pursuing multiple simultaneous legal battles, each consuming enormous resources and emotional energy, would eventually create problems even Harry's determination couldn't overcome. The security battle he couldn't win. While Harry celebrated his phone-hacking victory, another legal fight was delivering crushing defeats that exposed the limits of what courts could actually do for him. His battle to restore government-funded security protection would become the most emotionally fraught and ultimately futile of all his legal campaigns. The security issue had been festering since 2020, when Harry and Meghan stepped back from royal duties. The Executive Committee for the Protection of Royalty and Public Figures, a Home Office body, decided that Harry would no longer receive automatic, highest-level police protection when visiting the UK. Instead, his security would be assessed on a case-by-case basis. For Harry, this wasn't just an administrative decision, but a betrayal. He argued that his level of public profile, the documented threats against him and his family, and his status as a former senior royal meant he should retain full protection. He pointed to specific security incidents, including reports that a stalker had gotten close to him during a UK visit in September 2024. In September 2021, Harry launched legal action challenging Ravek's decision. His lawyers argued he'd been singled out and treated less favorably than other royals. They claimed Ravek failed to properly assess the risks he faced and didn't follow correct procedures in downgrading his protection favorably. The government's position was straightforward. Harry was no longer a working royal, and Ravek was entitled to make bespoke security arrangements based on that reality. They argued the decision was neither irrational nor procedurally unfair, and that Harry's legal team was taking an inappropriately hostile approach to Ravek's legitimate risk assessments. In February 2024, retired High Court Judge Sir Peter Lane delivered his ruling, and it was a comprehensive defeat for Harry. Lane found that Ravek's approach was neither irrational nor procedurally unfair. He dismissed Harry's central claims and validated the government's right to make security decisions based on royal status and role. Harry didn't accept defeat. He immediately filed an appeal, arguing that the judge had misunderstood key facts and that his security concerns warranted another hearing. In June 2024, after initially being refused, Harry was granted permission to appeal, giving him hope that he might reverse the setback. The appeal hearing took place over 2 days in April 2025, and Harry personally attended both sessions. According to the BBC and other outlets covering the proceedings, tensions in court were palpable. Harry's lawyer, Shahid Fatima KC, argued passionately that her client's security had never been properly discussed in a formal Ravek meeting, and that he should have been informed about how decisions affecting his family's safety were being made. Parts of the hearing were held behind closed doors to protect sensitive security information about royal protection protocols. Harry sat through hours of legal argument, listening as government lawyers defended the decision to downgrade his protection, while his own team tried to convince 3 appeal judges that the original ruling had been wrong. In May 2025, the Court of Appeal delivered its judgment, and once again, Harry lost. All 3 judges rejected his appeal, finding no legal error in the original decision. The ruling was decisive, and, for Harry, devastating. His reaction revealed just how emotionally invested he'd become in this fight. In a BBC interview conducted in California shortly after the ruling, Harry lashed out with language that shocked royal watchers and legal observers alike. He called the decision a good old-fashioned establishment stitch-up, suggesting that the judiciary had ruled against him not on legal merits, but because of institutional bias. This was extraordinary language from a member of the royal family, or former member, directed at British judges. It suggested Harry believed the legal system itself was rigged against him, that he couldn't get fair treatment in UK courts, and that the establishment was protecting itself at his family's expense. The outburst damaged Harry's credibility with many observers who had been sympathetic to his security concerns. Even those who agreed he faced genuine threats questioned whether publicly attacking judges who'd ruled against him was wise or fair. The judiciary had considered his case carefully across multiple hearings, dismissing their conclusions as a stitch-up, suggesting Harry couldn't accept that his arguments simply weren't legally sound. By late 2025, reports emerged that Harry had made another attempt, this time bypassing courts entirely. According to the Times, he'd written directly to the Home Secretary requesting a new risk assessment be conducted. Whether this approach would yield different results remained unclear, but it demonstrated Harry's unwillingness to accept the court's final answer. The security battle revealed a painful truth. There are limits to what courts can provide, especially when government bodies have legitimate authority to make operational decisions. But what exactly did it cost him? When legal costs became a courtroom scandal. By early 2025, a new problem was emerging in Harry's legal battles, one that would generate headlines almost as dramatic as the cases themselves. The sheer cost of his legal campaign was spiraling out of control, and judges were starting to express serious concern about whether the expense bore any reasonable relationship to what was actually at stake. The issue came to a head in January 2025 during a costs management hearing related to Harry's ongoing case against Associated Newspapers Limited, publisher of the Daily Mail. Harry and 6 other high-profile claimants, including Sir Elton John, Elizabeth Hurley, Baroness Doreen Lawrence, Sadie Frost, and former Liberal Democrat MP Sir Simon Hughes, were suing ANL over allegations of unlawful information, gathering spanning nearly 2 decades. Both sides had submitted their projected legal costs for taking the case to trial. The numbers were staggering. Harry's legal team estimated they would spend approximately 18 to 19 million euros. ANL's costs would be similar, around 18 to 19 million euros on their side. Combined, the two sides were projecting nearly 40 million euros in legal expenses to litigate claims that Justice Nicklin described as really rather simple. That phrase, really rather simple, cuts to the heart of the problem. This wasn't a complex commercial dispute involving billions of pounds or intricate technical questions requiring extensive expert evidence. It was fundamentally about whether ANL journalists and private investigators had used illegal methods to gather information about these claimants over a specific time period. Justice Nicklin and Senior Master Cook were clearly unimpressed. In their ruling, they slashed the approved costs dramatically. Instead of 18 to 19 million euros per side, they approved total budgeted costs of just 4,084,000 euros for the claimants and 4,445,000 euros for ANL. The decision represented a stunning rebuke to both legal teams, particularly to Harry's side, which had driven much of the case's complexity. The judges were essentially saying, "You're spending 4 to 5 times more than this case reasonably requires, and we're not going to allow it." For Harry personally, the implications were sobering. Even under the reduced budget, his share of the claimant's 4 million euros budget would be substantial, likely well over 500,000 euros, given that he's one of 7 claimants but probably accounting for a significant portion of the claims. And that's just if he wins. If he loses, he could also be liable for ANL's costs. The costs ruling also revealed uncomfortable details about how Harry's legal team had been operating. Documents disclosed during the hearing showed that the claimant's side had been paying witnesses for their evidence, a practice that's not illegal, but raises serious questions about the reliability and motivation of testimony. Justice Fancourt, in a separate ruling, ordered Harry's legal team to hand over documents relating to these payments. He wrote, "I am satisfied that documents held by the claimants that can support a case that a witness has been paid or offered other inducement for their evidence, whether directly or indirectly, should be disclosed." This opened a new line of attack for ANL's lawyers. At a preliminary hearing in January 2026, just days before the trial was set to begin, ANL's legal team made what were described as exceptionally serious allegations against some members of Harry's legal team, specifically accusations of dishonesty, fraud, and professional misconduct related to how witnesses had been recruited and compensated. David Sherborne, Harry's lead lawyer, pushed back forcefully in written submissions. The allegations made by the defendants are exceptionally serious, of fraud, dishonesty, and professional misconduct. They cannot be introduced by assertion in opening written submissions, and are not simply commentary on pleaded issues. He added that ANL's claims went far beyond attacking witness credibility. They were explicitly seeking findings of calculated attempts to mislead the court. These were career-ending allegations if proven, and they injected a new level of drama into proceedings that were supposed to be about phone hacking, not the lawyers themselves. ANL's barrister, Anthony White KC, told the court the submissions were simply an attack on witness credibility, not formal misconduct allegations. But the damage was done. The integrity of Harry's legal team was now under scrutiny, and the judge would need to carefully navigate these accusations. During the trial, Justice Nicklin, who had already shown impatience with both sides during preliminary hearings, issued warnings about the conduct he expected during the upcoming trial. While the specific language of those warnings remains partially confidential, observers in court described them as stern, reminders that the proceedings needed to focus on the actual legal issues, not on side battles between lawyers or theatrical demonstrations. The cost crisis also raised questions about Harry's financial sustainability. He'd already spent well over £1 million on his MGN case, though much of that was recovered through settlement. His security case had consumed substantial funds with nothing to show for it. Now he was facing potentially millions more in the ANL case, even under the reduced budget. Where was all this money coming from? Harry's post-royal income from Netflix deals, book advances, and speaking engagements was substantial, but not unlimited. Legal bills at this scale could consume years of earnings, and if he lost, and was ordered to pay ANL's costs, the financial hit could be genuinely serious, even for someone of Harry's wealth. Friends and sources close to Harry told various outlets that Meghan Markle was increasingly concerned about the toll, both financial and emotional, that these legal battles were taking. She wants him to be free of all of this, a former employee told People magazine. She wants him to live in a world where he is not burdened by this. But for Harry, there was never really a choice. He understood the cost and accepted it as the price of confronting systems he felt had wronged him. What he does next, however, is something few saw coming, and it will leave you stunned. The newsgroup settlement nobody expected. Just when it seemed Harry was committed to fighting every tabloid publisher in court, regardless of cost or consequence, he pulled off a stunning reversal that shocked royal watchers and legal observers alike. In January 2025, just days before a highly anticipated trial was set to begin, Harry settled his case against News Group newspapers, the company behind The Sun and the now-defunct News of the World. This was the case Harry had been building toward for years. NGN, owned by media mogul Rupert Murdoch, represented the heart of what Harry saw as tabloid villainy. The now-defunct News of the World had been at the center of the original phone hacking scandal that rocked British journalism in 2011, leading to criminal prosecutions and the paper's closure. Harry's claims against NGN covered alleged unlawful information gathering from 1996 to 2011, spanning his entire childhood and young adulthood. He had argued that both The Sun and News of the World had systematically targeted him, his relationships, and his family through illegal means. The trial was supposed to be the big one. 8 weeks of daily testimony, evidence, and headlines exposing what Harry believed was the worst of tabloid misconduct. NGN executives and former journalists would be cross-examined. The roles of senior figures, potentially including Murdoch himself, would be scrutinized. It would be the MGN trial multiplied many times over. And then, suddenly, it was over. On January 23, 2025, NGN and Harry jointly announced they had reached a settlement. While financial terms remained confidential, multiple reports put the overall value at more than 10 million euros, covering both damages and legal costs. More significantly, NGN issued a public apology that went beyond the typical corporate statement. The company acknowledged unlawful activities carried out by private investigators working for The Sun. They admitted to intrusion into the private life of the late Diana, Princess of Wales. And they offered a full and unequivocal apology to Harry for the impact of this unlawful conduct. For someone who had spent years seeking acknowledgement of wrongdoing, this was a substantial victory. NGN, which had fought these allegations for over a decade and had never before admitted liability in this way, had been forced to apologize publicly and pay a fortune in compensation. So why did Harry's supporters and critics alike react with surprise and, in some cases, disappointment? Because settling meant giving up the opportunity for 8 weeks of damaging revelations about NGN's practices. It meant Murdoch and his executives wouldn't face detailed questioning in open court. It meant the full scope of wrongdoing, if it existed beyond what NGN acknowledged, would remain largely hidden. Harry got his apology and his money, but he didn't get the comprehensive public exposure of NGN's operations that many had expected him to demand. Rather than 2 months of daily headlines about tabloid misconduct, he got 1 day's worth of settlement stories, and then the world moved on. Critics suggested Harry had been bought off, that NGN had paid enough to avoid the embarrassment of a trial. Supporters argued Harry had won everything that mattered: acknowledgement, apology, and compensation, without enduring weeks of stressful testimony and cross-examination. The settlement also revealed something about the limits of Harry's stamina for these battles. By early 2025, he'd been fighting in courts for years. The emotional toll of the MGN testimony, the crushing defeat on security, the mounting costs, and the strain on his marriage were all taking their toll. Perhaps settling with NGN wasn't about the money. It was about recognizing he couldn't fight everyone simultaneously. 2 days after the NGN settlement, Justice Nicklin's ruling on legal costs in the ANL case dropped, further highlighting the financial pressure Harry was under. The timing seemed more than coincidental. Harry had just avoided an expensive 8-week trial with NGN. Now he was facing stern warnings about costs in the ANL case. The pattern suggested someone who was starting to count the actual price of his crusade. But did Harry stop at that, or simply pressed further? Harry's last stand. With the NGN case settled, Harry's legal attention turned entirely to what many observers now see as his final major courtroom battle: the case against Associated Newspapers Limited, publisher of the Daily Mail, Mail on Sunday, and Mail Online. This is the trial that actually happened, beginning on Monday, January 14, 2026, at London's High Court. Harry appeared personally at preliminary hearings in the days before trial commenced, a sign of just how seriously he's taking this case. On Thursday, January 22, 2026, he entered the witness box to give evidence, his second time testifying in a phone hacking trial. But in many ways, his most important court appearance yet. His written witness statement, submitted to the court and reported extensively in the media, painted a disturbing picture of his early life. Harry described feeling paranoid beyond belief due to the Mail's coverage of him. He detailed how the constant intrusion from the newspaper made him distrustful of people around him, damaged relationships, and contributed to lasting psychological harm. "I was distressed and disturbed by the intrusion of my early life by the Mail," Harry wrote. The statement ran to dozens of pages, chronicling specific instances where he believed illegal methods had been used to obtain information about his private activities, relationships, and family matters. The allegations against ANL are sweeping. Harry and his 6 co-claimants accuse the publisher of engaging in a clear, systematic, and sustained use of unlawful information gathering, spanning roughly 2 decades, from as early as 1993 through to 2011, and potentially beyond. The specific allegations include hiring private investigators to place listening devices inside cars, blagging of private record, accessing and recording private phone conversation, and illegal information gathering through various means. These aren't minor accusations. If proven, they would demonstrate that one of Britain's most powerful media organizations systematically broke the law for years to generate stories about Harry and numerous other high-profile individuals. ANL has forcefully rejected every allegation. The publisher describes the claims as preposterous and an affront to responsible journalism. Their defense rests on several arguments. First, they flatly deny that any unlawful information gathering took place. ANL insists its journalists operated within the law and that Harry's claims are based on speculation, paranoia, and attempts to blame the newspaper for his own life choices. They also argue that many of Harry's claims are too old to be legally actionable. They contend that the phone hacking allegations, even if true, relate to events so far in the past that they're beyond the legal time limits for bringing such claims. It also rests on the fact that ANL has launched aggressive counterattacks on Harry's credibility and that of other witnesses. As revealed in preliminary hearings, ANL's lawyers have made serious allegations about how Harry's legal team recruited and potentially compensated witnesses, raising questions about whether testimony has been influenced by payments or other inducements. The trial, scheduled for 9 weeks, represents a massive investment of time, money, and emotional energy for Harry. Unlike the NGN case, which he settled just before trial, Harry has chosen to see this one through to the end. That decision speaks to both his determination and perhaps his recognition that he needs a conclusive win to justify the years of legal warfare. Defense lawyer Anthony White, KC, immediately began cross-examining Harry when he took the stand, challenging his written evidence and questioning the basis for many of his allegations. Cross-examination can be brutal, designed to expose inconsistencies, challenge assumptions, and undermine a witness's credibility. Harry, having been through it once before in the MGN trial, knew what to expect, but that doesn't make the experience any less stressful or confrontational. Other claimants, including Baroness Lawrence, Sir Elton John, and Elizabeth Hurley, are all expected to give evidence during the 9-week trial. Each will face similar scrutiny, their claims examined and challenged in forensic detail. Justice Nicklin, who has shown increasing impatience with both sides during preliminary proceedings, issued stern warnings before trial began, while the exact content of those warnings remains partially confidential. Court observers described them as reminders that the trial needed to focus on evidence, not theatrics or side battles between legal teams. The judge faces a difficult task. He must navigate allegations of legal team misconduct, manage a complex case involving 7 claimants and 20 years of alleged wrongdoing, control legal costs that both sides wanted to push into absurd territory, and ultimately deliver a fair judgment that will be scrutinized globally. For Harry, this trial is about more than just ANL. It's about validating his entire legal strategy, proving that his years of court battles have been worth the cost, and demonstrating that holding tabloids accountable is possible, even when powerful publishers fight back with every resource at their disposal. If he wins, it will provide vindication and potentially significant damages. If he loses, it will suggest that his claims of systematic unlawful targeting were exaggerated or unprovable and could leave him liable for millions in legal costs on top of what he's already spent. The stakes couldn't be higher, and everyone involved knows it. What do you think about Harry's legal crusade? Were the victories worth the enormous cost? Share your thoughts with us in the comment section. Remember to like, share, and subscribe for more. Also, click the next video showing on your screen. You will enjoy it.